Hello, everyone. This is John Bruegger at California Southern University School of Law. Welcome to Week 3 of Torts 1, Law 5110A. This week we're going to be continuing our conversation about intentional torts. And remember from last week, we talked about intentional torts of battery, assault, and false imprisonment. And all the intentional torts are defined by this aspect of intent. What is intent? That the act is done for the purpose of causing the behavior, purpose of causing the contact or apprehension, or the act was done with knowledge that such contact or apprehension is substantially certain to be produced. So, in order to have an intent for an intentional tort, you have to have intended to undertaken the behavior that you're undertaking, which causes the tort, or that such behavior, such contact, is substantially certain to be produced. So, last week we talked about 3 intentional torts. This week we will talk about 3 more, and then we will finish this discussion next week. So this week we are talking about intentional infliction of emotional distress, trespass to land, and trespass to chattel. Intentional infliction of emotional distress was not widely accepted by the states in its original form. Looking back to the restatement of torts, which, of course, restatements are not actually laws. They're just a summary of what the law should be as determined by the people who write the restatements. And they're not law until they're actually enacted as law by the states. So we have the original restatement of torts in 1947, stating that one who, without privilege to do so, intentionally causes severe emotional distress to another is liable, A, for such emotional distress, and B, for bodily harm resulting from it. So you'll see that in this original form, states were not really excited to just create a new tort based on mental harm or mental distress. That the states that were willing to let this go out to actually form a new cause of action, a new tort in that state, had to be some sort of extreme emotional distress and bodily harm resulting from it. So let's look at a couple of early cases. State Rubbish Collectors Association versus Siliznoff. This case you can imagine as some of the old, maybe mob-controlled public services. In this case, it was trash collection. The plaintiff was collecting trash in an area that was being controlled by this Trash Collectors Association. They told him that he needed to remit his trash collection fees to the association, or they were going to beat him up. And he was forced to sign some notes to evidence the repayment of those fees to the association. So he sued to get out of those notes and for assault because of the threats that were made to him. So in the context of intentional infliction of emotional distress, the court said that generally the law does not protect one's mental tranquility from invasion. However, when the mental distress rises to the level of resulting in a bodily harm, there could be liability for the harm caused. So, and also, even if the defendant did not mean to cause harm, liability would attach as long as the occurrence of bodily harm could be foreseen. Again, this is intent. So if the defendant intended to create the emotional distress, or it was substantially certain that the emotional distress would occur, then there could be intent here and there could be liability. Let's look at the Slocum case. This isn't just an insult case. Plaintiff was a customer in defendant's store. She asked the employee for the price of an item, and he made a comment to her that she stinks. She alleges that she had mental suffering as a result of the insult and some physical symptoms that were derivative from her mental suffering. The court looked at this and asked the question of whether the insult itself can state a cause of action in tort, absent the occurrence of any other torts. So, as we saw in the other case, the Siliznoff case, that there was intentional infliction of emotional distress, but it was combined with an assault because they had threatened to physically harm him. In this case, it was just a comment, just an insult. And the court here in Florida decided that, look, there were a few cases that they allowed intentional infliction of emotional distress to lie, and that was usually in the case of common carriers, hotels, theaters, and even a telegraph office. But they weren't really excited about extending the law to cover generally all cases where a business invitee was insulted by the business. So they found in that case that there was no cause of action for intentional infliction of emotional distress. So over time, this rule changed, and they had this new standard of extreme and outrageous conduct. More states began adopting this. Let's look at the Harris versus Jones case from Maryland. This is a case involving a GM employee who had a severe stutter and was also very sensitive about his stutter and very anxious about his stutter and the way he was being treated. He had several supervisors and co-workers at GM. He worked on the assembly line, so several of his supervisors and co-workers mocked him about his stutter and caused him severe emotional distress. This went on over the course of several months. It wasn't just a one-time occurrence. So the court looked at the intentional infliction of emotional distress as a separate, independent tort from what we had seen previously as infliction of emotional distress as combined with another tort. So here, these are essentially the elements that must be shown to show intentional infliction of emotional distress. One, the conduct was intentional or reckless. Again, this falls in line with the intentional torts. The conduct must be extreme and outrageous, and as you can imagine, the term extreme and outrageous is probably defined by hundreds of cases out there on what specific facts lead to a conclusion that some conduct is extreme and outrageous. The wrongful conduct has to have a causal connection to the emotional distress. So the emotional distress has to be caused by whatever the extreme and outrageous conduct was, and not something else. And then the emotional distress that's caused has to be severe. So it can't just be a slight emotional distress. It can't be just any kind of offensive conduct. These are seem vague, but these are the standards that are in place for intentional infliction of emotional distress. The court also held in this case that whether something is extreme and outrageous is a fact question for the jury. Although the court didn't decide in this case that the conduct was extreme and outrageous, they declined to answer that question because they held that there was insufficient evidence that the fourth prong, the emotional distress is severe prong, was not met, that the emotional distress suffered by the plaintiff was not severe, and therefore they didn't have to decide any of the other questions. But from this case, you can see the new rule. You have to have extreme and outrageous conduct and severe emotional distress for this cause of action to lie. So let's look at another case. This Taylor case involved Clifford Taylor, who was attacked and beaten by a group of men. Mr. Taylor sues for battery. His daughter was also present at the beating and witnessed the beating. She brings an action to recover for her severe fright and mental distress. The court looked back at previous cases in intentional infliction of emotional distress, and they agreed that the cause of action could lie if the right elements were met. They made this analogous case of, if A and B are married, and C hates B, but C is friendly to A, and A is on the porch of her house, and B is in the front lawn, and C comes up and kills B in the presence of A. Knowing that A was there, then C could be liable for A's emotional distress. In this case, in the Taylor case, the court said, look, it's not analogous to that. There was no evidence that the defendants in this case knew that Mr. Taylor's daughter was present, or there was no evidence that the beating was conducted for the purpose of causing her mental distress, or that her emotional distress would be substantially certain to result. So they committed the beating, but they're not liable to her because there's no evidence that they knew she was there, so there was no intent to cause her any kind of harm or do the beating with respect to what it would cause to the daughter. So let's move on to the next tort we're talking about this week. Trespass to land. This sounds like any kind of trespass that you would recognize. Trespass to land is essentially the unauthorized entry onto land by someone without the right to be there. So if you enter onto someone's land and you do not have permission to be there, then that is a trespass to land. Looking back at this 1835 case, the Dougherty case versus Stepp, plaintiff sued for trespass, and because the defendant came onto the land with a survey crew and took measurements. There was no damage that occurred to the land. They didn't cut down trees. They didn't damage bushes. The Supreme Court in the state of North Carolina held that the defendant's actions on the land go to the amount of the damages that were incurred, but not to whether there was an actual trespass. So you have two issues here. Was there a trespass? And if the court finds there were trespass, the court will at least find that there are nominal damages. And you'll see this in the cases sometimes. The court will award $1 in damages. So if there's a trespass to land, then there's at least nominal damages. And if there are actual damages to the property, then those get added on as well. And you'll see this is a very different standard than what we'll talk about in a minute with regard to trespass to chattels. So let's look at the Heron versus Sutherland case. This is a case where the defendant was standing on a parcel of land that was not owned by the plaintiff, but he was hunting, and he fired his shotgun over plaintiff's land at some waterfowl. Plaintiff had cows and other things on his land, so plaintiff sues him for trespass. The defendant says, look, I never entered his land, I didn't come on his land, there's no trespass. But the court stated that you have to look at the historical definition of what property rights were. Property rights were deemed to extend both up to the heavens and down to the earth, center of the earth. The court realized that standard may have to change over time. If the government is shooting a missile over your land, but that missile is very high in the sky, there's probably not going to be a recognizable trespass there because it's not interfering with the land whatsoever. But in this case, someone shooting a shotgun through the air that's pretty close to the ground, that will cause there to be a trespass just as much as violating the soil. It violates the plaintiff's quiet enjoyment of his own land. So in this case, shooting a shotgun over plaintiff's land is considered a trespass to land. So let's look at the issue of consent. If you give someone consent to be on your land and then they overstay their welcome, is that a trespass? The Rogers case, there was an agreement between the plaintiff and the Board of Road Commissioners for Kent County to build what's called a snow fence during the winter. So the defendants had the permission to come onto the land to erect this snow fence, and then at the end of the season, when it was no longer needed, they would take it down. And so that's what they did in this case. They put the fence on the land. At the end of the winter, they took it down. Unfortunately, they left behind a fence pole that stuck out of the ground a little bit, and it was covered by grass. The plaintiff's decedent was mowing a lawn, ran the tractor over the hidden fence pole. It caused him to get thrown from the tractor, and he was run over and killed. So, the Board of Road Commissioners said, look, this is not trespass, this is not an intentional tort, this is negligence. We were negligent in not taking the pole out of the ground, but this is not an intentional tort. And the court held that if you have permission to be on the land, you have a license to be there, and that license expires, then your continued presence there is a continuing tort for trespass to land. So they had permission to erect the fence and to be there as long as the plaintiff agreed that the fence could be there. But once the license expired and they removed the fence, leaving that fence post behind was a continuing trespass to the land. And in this case, one that caused extensive damage because a person was killed. So let's talk about trespass to chattels. Chattels are personal property as opposed to land, which is real property. As we said, trespass to land can result in nominal damages, even if there are no actual damages. So if there's any trespass at all, even if there's, I take one step onto your land, I don't hurt anything, I don't kill anything, I leave right away, that's still a trespass, and the court could still find me liable, even if it's just for nominal damages. Trespass to chattels, however, the courts require some sort of damage to the chattel. Harmless interfering with another's chattel will not support a claim for trespass to chattel. So let's look at this Glidden case. In this case, the plaintiff, a 4-year-old little girl, was playing with a dog owned by the defendant. She was playing roughly with the dog, and the dog ended up biting her on the nose. She had surgery and recovered from that, so she sues for the injury. The defendant says, look, I'm not liable. She committed a tort by interfering with the dog. This is a trespass to chattel, and therefore there's because she committed the intentional tort, defendant is not liable for her injury. And the court here held, look, to find trespass to chattel, we have to find. So looking at this case, the dog bite case, the court held that there's no evidence that by her interfering with the dog that she caused the dog some sort of harm. There's no harm to the dog by her playing with the dog. Therefore, the court's not going to find some sort of nominal damage of trespass to chattels. There has to be some actual damage that occurs here. Let's look at a case that's a little more recent than the ones we've been looking at, but seems like a lifetime ago, given today's progress with the internet. So let's look at CompuServe Inc. versus Cyber Promotions. This is a federal case from the Southern District of Ohio in 1997. Let's take a little walk back in time. CompuServe was a company like AOL and some other companies that provided users with a subscription, gave them an email address, they had access to proprietary content through CompuServe, and also they had access to generally the internet. This is a time when not many people had broadband internet, and so if you had internet in your home, and I used to have a CompuServe email address, if you had internet in your home, you would go on your computer, it would go through a dial-up modem, it would dial into some sort of computer bank that was owned by AOL or CompuServe, and then you would connect to the internet that way. And they controlled your email, they controlled your access to the internet, they controlled all of that. So in this case, Cyber Promotions is a company that sends out spam emails. They send out large mass unsolicited emails to CompuServe users. CompuServe, because a lot of their customers were complaining about all the spam mail they were getting, CompuServe created software to filter out the spam messages, but then defendant would just change what they were doing and mask where the emails were coming from to get around the software. CompuServe eventually sued them for trespass to chattels by arguing that the defendant was making unauthorized use of CompuServe's computer equipment to send its spam messages. So the court in CompuServe looked at the new Section 218 of the Restatement Second of Torts. The one we looked at before was the original Restatement of Torts. So in the Restatement Second, the court looked at the issues of there was a trespass to chattel if and only if the defendant dispossesses the other person of the chattel, or the chattel is impaired as to the condition, quality, or value, the possessor is deprived of the use for a substantial time, or there is bodily harm caused to the possessor, or harm is caused to some person or thing in which the possessor has a legally protected interest. So the change here is that subpart A is this idea of dispossession of the chattel, although that doesn't really come into play in the CompuServe case. So with regard to the facts of CompuServe, the court looked at it and said, there's ample evidence here that all of these spam emails are clogging up CompuServe's computers. They have to store these bulk emails and try to somehow return them to an return them to an address that doesn't exist. And every time they're doing that, it puts a substantial burden on their computer equipment. This is equipment that then cannot be used to service their customers or provide their customers with benefit. Therefore, their use of their own equipment is being impaired by these spam emails. And they also looked at this idea of CompuServe's legally protected interests. They have these customers. The customers sign up with CompuServe because they want email, they want access to CompuServe's services and proprietary content, and they also want access to the internet. But if they're signing up for all of this and they're paying a monthly fee or an hourly fee, and they're getting, their emails are just bombarded with spam emails, and back in those days, not only did you have crazy adware and malware that would pop up and just destroy your computer, but you would have emails that would just, you would have 3 emails out of 200 because there was so much mass marketing going on. So customers would get mad at this, and then they would cancel their accounts. So the court looked at it and said, look, CompuServe has this legally protected interest in their customers that have signed up for them, their subscribers, and because the action of defendant it's harming their legally protected interest because it's causing people to unsubscribe to CompuServe. So therefore, there was a trespass to chattel in this case. So, short video for this week. We just talked about 3 intentional torts. Intentional infliction of emotional distress. Originally not widely accepted by the states. Eventually more states came around. But the standard you need to look at now is whether the conduct that occurred was intentional or reckless, whether the conduct was extreme and outrageous, whether the wrongful conduct was causally connected to the emotional distress was caused by the conduct, and that the emotional distress is severe. With regard to trespass to land, the courts will deem any kind of unauthorized entry into someone else's land without permission as a trespass that can result in damages even if there's really no harm to the land. They can fine for nominal damages, and if there's actually any harm to the land, then those are just additional damages that can be recovered. Finally, trespass to chattels. We're looking at the rule from the second restatement of torts that one who commits a trespass to chattel does so when he dispossesses the owner of the chattel of the possession, when the chattel is impaired as to its condition, quality, or value, the possessor is deprived of the use of the chattel for a substantial time, or bodily harm is caused to the possessor, or harm is caused to some person or thing in which the possessor has a legally protected interest. And again, the difference between land and chattels is trespass to land, there can be nominal damages for any trespass that occurs, but with chattels, there has to be some sort of damage that occurs, and you'll see the 4 different things here that, with any one of them being satisfied, would result in a trespass to chattels. But again, the court's not going to recognize some sort of harmless interfering with someone's chattels. It has to meet one of these prongs. There has to be some sort of harm caused by the interference. So next week, we'll pick up where we leave off here. We'll talk about the rest of the intentional torts, and then we will move on to the defenses to intentional torts. If you have any questions or concerns, shoot me an email or give me a call. Good luck this week.